Looks like the parties are ready. Mr. Howe.
May it please the court. Counsel. Not all searches incident to arrest are the same, and the Court of Appeals erred when it flattened these distinctions and applied the inapposite Gant and Gaskins search incident to arrest exception to this Robinson search. This court should correct their mistake, vacate their opinion, and affirm the district court. I'd just like to start at the 20,000-foot view for this instance and talk about the three different contexts for search incident to arrest. Initially announced in Kymel, but we'll come back to that in a moment. I want to start on basically scopes coming out. When we're talking about the arrest of a person and items that are immediately associated with their person, their clothing, their jackets, containers within those containers attached to their bodies, those searches require no justification. They are reasonable as a result of the arrest. Your Honor, do you have a question?
That reminds me, one of the questions I wanted to ask right out of the chute was, Blue Brief says that this case is identical to the unconstitutional search in Gaskins, and that was actually the point I wanted to make. You tell me, what do you think are the distinctions other than in Gaskins, the gun was in a glove box, I remember, if I'm correct. And in this situation, it was outside the car after the defendant knew that what was going on and handed off something. So help me understand, is this identical or not? And if not, how are they different?
They are not identical in any way. Gaskins was a case involving a search incident to arrest beginning in an automobile. In this case, Your Honor, the video depicts how Officer Bolstad encountered Mr. Scullark outside of a house. He was sitting on the truck, but he wasn't pulled over. He was just sitting there. The officer arrived there independently. And when he announced, hey, we need to talk about this domestic, I'm intending to arrest you, Mr. Scullark bolts into the residence over the officer's objections. And once there's a quite emotional confrontation in which he insists he can't go back to either prison or jail, but he can't be incarcerated. He hasn't done anything wrong. At this point, Officer Bolstad is alone with Mr. Scullark and two of his associates who are trying to comfort him, but he's quite distraught. The two cases are not the same. And returning to my line of discussion, Kymel is the second exception to the search incident to arrest. And in that instance, that is what authorizes officers to search the immediate area around a arrestee. That's talking about a desk, drawers in a desk. It talks about, I would say, the space immediately around them. And then the third one is the automobile exception discussed in Gaskins as well as Gant. And I think it's fair to say, I don't mean to take up too much time on this because I don't think it's at all applicable, but Gant is a reaction to Belton as discussed in Thornton. It's a expansion and then a contraction of this third context, the search incident to arrest involving vehicles, which again is distinct from the one we're talking about here.
If you wanted to make an automobile analogy to this case, I think I wrote an opinion for the court in Rincon a few years ago where there was, the law enforcement had the right and authority to search the vehicle, and this person gets out with her backpack as if that would somehow insulate the backpack from search. And we said, no, that doesn't work. And this is the same thing, kind of thing.
Reasonable searches shouldn't turn on games of hot potato in which a defendant or arrestee is able to quickly enough move the bag away from their person. Rincon was correctly decided.
In Gant, I think the general principle established for the exception was officer safety or to find evidence that relates to the arrest that the officer is conducting. In this case, I don't think that there was anything, starting with that second point, that there was anything that they were looking for relating to the domestic assault that was in that fanny pack. And by the time the officer looked inside, Mr. Scullark was already handcuffed and he was about to enter the squad car. And so I struggle to see any public safety rationale. And so if we were to look at this in the same view as Gant, would this fail?
To start from the top, I think your example demonstrates why the three categories function the way they do and why this is not a Gant and a Gaskins search. In no other context of this trifecta, for Robinson searches or Kymel searches, is the ability to search for evidence, a rationale under supporting it. It's only in the automobile context that that applies. So to come back to your question, do I think it's possible that a search of this fanny pack could have revealed evidence relevant to the domestic abuse allegation? I think it's possible if we had documentation proving up his residence, if there was the watch that was alleged to have been thrown at the individual. It's possible we could have obtained that evidence. But again, we're talking about separate interests justified by each of the contexts. And here, when we're talking about an arrest of an individual in a highly charged environment, that's when the Robinson version of it makes the most sense, where there is a danger to not only the officer, but the people in the immediate area, that if the arrest goes sideways, something violent could occur. And as Riley recognized, any physical object in this context is possibly dangerous. And so the search is categorically reasonable. We don't need to establish an independent objective purpose for it. Now, to play out your other, oh, sorry, please go ahead.
He didn't possess it at that point, right? Scullark didn't actually have it. And so what was the danger that would have arisen based upon, I think her name was Tina's holding of this fanny pack?
So I think it's a little bit favorable to assume that everybody present with Mr. Scullark had the state's best interests in mind. So let's say that, I believe, not to actually you, but I believe her name is Tammy. No, you're fine. When Tammy takes the bag, any number of things aside from her holding it for a moment until the officer directs her to drop it could have happened. If there had been a weapon inside of it, she could have seized it and used it on the officer. That's why the seizure is immediately reasonable. That's why the search of it is immediately reasonable. Now, I think your question is getting at possibly how the Knapp and the 10th Circuit addressed the question, which is that we should examine these in the second Kymel context as the time of the search to make sure that the justifications for the search are actually being served. But even then, those interests are still being served here. Again, we are talking about officer safety in the context of a dramatic arrest. And I will say, you're correct. He's not inside the vehicle he's about to be. But I also think he's within the immediate reach. And it's not in the record, of course, but even 10 minutes of Googling will demonstrate that there are numerous instances in which handcuffed individuals obtain weapons and assault the officer arresting them. There was at least 2 in 2020 and 2022. There was 1 in Maine in 2024. These are not impossible events. And the interests of the search incident to arrest exception, even under a time of search analysis, those interests are served here. I would also just like to talk about how the majority has introduced instability into our law by jettisoning its previously decided cases. I think some of them might need to be recontextualized after Riley to make sure that we're being consistent in the context we're applying, but all of them were lawful under either the Robinson or the Kymel formulation. For example, in Hershey, it was a purse that the individual was holding when confronted by the officer, and the officer physically took it from her to search for a shoplifting incident. That would be a classic Robinson situation where the arrest is going on and the purse is immediately attached, actually possessed by her at the time of the search. Turning to the cases specifically relied on by the district court here, there's Saxton, Allen, Jones, Shibut, and all of these are various iterations of either something actually possessed by the individual at the time the arrest is about to occur. In Shibut, she was about to cast it off and then re-grabbed it, or instances in which it was within the individual's reach at the time of the arrest. And that's the rule for the second context, the Kymel exception that the state's urging for here. When we're talking about a search, if we're going to talk about what is reasonable inside the immediate area, we should determine that rule from the moment the arrest is announced and effected. Otherwise, we are encouraging games of hot potato. We are encouraging people casting things off to Confederates or family members.
When did the officer announce that he was under arrest? Was it in the house?
Gosh, certainly it was repeated in the house. It might have been announced at the truck, and that's what caused him to go inside.
Handing the fanny pack to Tammy.
Announced that he was going to be going. That's when Mr. Scullark handed off the fanny pack to his friend.
Arrest at that point. Okay.
The intent, he's
ready as the fanny pack is being handed off.
realizes what is in that bag is going to accompany him back to the police station, it becomes paramount that he gets it off his person. And that's another reason why if we're doing the second Kymel version, we should be looking at the time of the arrest, because even if the interests are somewhat minimized, are lowered at the time of the search, if the individual is handcuffed, it's still consistent with the purposes underlying the entirety of the exception to ensure that officers are safe, that we are not permitting people to subvert the arrest. I also just would like to note that this is just a search consistent with common sense. We shouldn't be asking our officers to acquiesce in events that would result in their harm. It's contrary to common sense. It's contrary to our law. And I would just briefly, finally, like to talk a little bit about 814.6 sub 3 while I have the court's attention. I don't think it was necessary to gloss the statute in this case. I would be forthright and say that the state waived the matter. We do not believe that this is an instance in which the court lacks jurisdiction, but I don't think we need to define a statute in the absence of adversarial briefing. Those cases, I assure you, will come. One is to be submitted next month, State v. McLean.
There could be a situation where the state agrees below that a conditional guilty plea can be taken in order so that the defendant may have the appellate court consider a matter, and then it gets up on appeal and the state feels, no, there is no jurisdiction. They can change their mind.
Provide a little more context to my last statement and to answer your question, Justice Mansfield, there will be instances in which the parties agree that a certain claim should be presented to the appellate courts for adjudication, and somewhere between the district court and the blue brief, something changes. And if that issue is not consistent with the rules of criminal procedure, not consistent with 814.6 sub 3, at that time, yes, the state will cry foul and point out the error and the lack of jurisdiction.
This case?
To be quite clear, Justice Waterman, that's part of the reason for the awkwardness of the state's position here on further review, but I wanted to be candid with the court. We're not objecting to it here, but we don't need to define the statute when we don't need to. Justice May, please.
Of what you're saying then that would be permissible, is it any different than an error preservation analysis?
Very similar, especially because when we're talking in 814.6 sub 3 about reserving an issue, I think to reserve an issue, you had to actually present it, you had to actually provide some specificity. It would need to be timely. We would need a decision, and I believe you would need to have requested an appropriate remedy. I think this court, more often than we might care to admit, sees requests for remedies that just are impossible to grant, and that might be another reason why it would not be in the interests of justice, because if there's no possibility of granting the remedy that's requested, reserved or not, it's not a good use of appellate resources. And I think the way the statute is written, it reserves to this court the ability to determine when those criteria are met. For the foregoing reasons, because this was a lawful Robinson search or even a lawful Kymel search, the Court of Appeals erred in applying this court's past announcements in Shane and its own past precedent. It misapplied the Fourth Amendment as described by the United States Supreme Court, and it frankly defined a statute that didn't need definition quite yet. I will speak to you again on rebuttal.
Thank you. And Mr. Irwin.
Thank you, Your Honor. May it please the court, counsel. I'd like to begin by just a point of clarity. There is no such thing as an independent search incident to arrest of a vehicle doctrine. The state has advocated there are 3 categories of search incident to arrest. That's incorrect. There are 2. There are search incident to arrest of the person and immediately associated items. There are searches incident to arrest of other items. Your Honor?
Limited to cars?
Because Gaskins correctly applied search incident to arrest principles as announced. Frankly, in Gantt, I think there was some confusion at the time of Gaskins exactly what, and it remains to some extent today, exactly what the federal position was on Gantt. And so said, look, we'll just bypass all of that. Under Iowa, it's not a valid search incident to arrest if the person can't reach the object. If it's in a car, if it's anywhere else, it's totally irrelevant.
Counsel, is the state just wrong to put so much reliance on Robinson in this case?
Yes, Your Honor, but for a different reason. The state is incorrect to put so much reliance on Robinson because this was not a search of Mr. Scullark's person. This was a search of a container which Mr. Scullark did not want to bring with him. The officer insisted he bring with him.
This is a practical matter because I feel like what is being advocated sort of for the defense is that the police officer, by being sort of patient and letting him get rid of the fanny pack, the state sort of put themselves in a worse position from an evidentiary point of view than if the cop would have just, I don't know, tackled him from the very beginning of the arrest, and then he'd have the fanny pack and the person, and that would be super dangerous for everybody, and everybody agrees that wouldn't have been the best way to approach it, I assume.
Yes, Your Honor, and I would say that most of what the officer in this case did was perfectly acceptable. I understand he was faced with a contentious situation. He was outnumbered at the beginning. He was absolutely within his rights to order the third party put that down. The problem is he is not within his rights to say, I'm taking that because it was with you, we're searching it, period, we're done.
Again, to get the fanny pack, he needed to just go and grab the fanny pack and not let him give it away.
Yes, Your Honor, although I would also note, and this gets to some of these sort of gamesmanship concerns that the state points to, it is not reasonable for an officer to intentionally place themselves in danger to ensure that they can search something. Justice Scalia talked about that in his Thornton concurrence. And I think that is, the danger in this case comes from the fact that the officer insisted on bringing that pack with him, even though Scullark didn't want it.
This out. So, Mr. Irwin, you concede that he could have told the woman who was there, put that down and leave it, and then he could have gone and gotten a warrant later to look at it.
Had any probable cause. The problem here is there's no probable cause whatsoever to search that fanny pack.
Yeah, well, we don't know. But let me just finish, if I could. So then, what if the person said no and started walking away?
Then the officer, well, first that person will have at that point likely committed interference with official acts, so they're probably subject to arrest. But even if they hadn't, Terry principles address all of the third-party concerns the state is talking about. Search incident to arrest has nothing to do with third parties. That's once we're talking about the danger a third party might pose, we are out of search incident to arrest territory, and we are potentially in Terry territory. Sorry, yes, Your Honor.
What about the argument that this fanny pack could have had evidence of this crime, that it may have had the watch in it that hit her, may have had a driver's license in it, may have had something that would have helped with the investigation of this crime?
Yes, Your Honor. Regarding the watch, exactly where escapes me. I feel there's something in the record indicating the watch stayed at the scene. I'm sorry, I couldn't point exactly where in the record, but I don't think there was any belief that the watch was in that bag. As far as identification, it's tricky because, of course, that would only be relevant if they were going forward with a prosecution for domestic assault, and it's somewhat unclear. I know the officer referred to it that way, but then the complaint filed, if I recall correctly, is normal assault, and he was never charged with that. And so perhaps if it were a domestic abuse case, it's unclear to me that it is based on the record that we have.
Ask him if he had lived with the complaining witness. He said, yeah, he did. So it seems like that was what the officer was looking for.
Asking that question? Yeah, I agree. Yes, the officer was doing some investigation by asking that question, but it's completely different than the entitlement the officer displayed to just open and search this container simply because Scullark had it, but was trying not to possess it at the time he was arrested.
I understand your argument. So you're not contesting the authority to conduct a search of the person and anything on their person at the time of arrest, correct?
At the time of search, Your Honor. The distinction is I think that people are free to put an object down at the time of arrest, and police cannot do anything about that, barring Terry implications, probable cause to seize the item. My main argument is the officer was not entitled to not allow Scullark to put the bag down.
The rationale for that. So the Supreme Court has said that if you search a person incident to arrest, there doesn't have to be any reason to search any containers on their person. It's just justified by the fact of arrest. So why does the person dropping a bag on the ground or wherever he put it in this case, I think he set it on something and then the woman grabbed it. Why does that change the rationale underlying the search incident to arrest doctrine? I guess I don't understand that.
No longer part of his person, Your Honor. It's not his clothing, it's not containers within.
And the cop, but because he can sense the cop's going to arrest him, that doesn't, I can just imagine all the shenanigans that are going to happen. As soon as they sense arrest, boom, drop it, and then it's off limits.
If there is no grounds for the officer to seize or search the item.
Imagining, I haven't said anything till now, but domestic abuse, I can think of lots of ways that something in there might be relevant. And I think the questions he's asking, oftentimes somebody gets charged with one offense, but by the time it gets to the indictable trial information, it's changed a bit because they've learned more. So it could be morphing from assault to domestic based on what they find. Let's say she says he has a silver little ring that whenever he takes that out, that's a word for me to behave, or I'm going to get it. And then all of a sudden, that's in the bag, for example. I'm making that up from an old case I remember. It was a symbol for her. So if later on she tells him, you know what, he carries a silver ring with him, whatever. There's just an example where, damn, that just supported what the cop was saying. So I am not so dismissive of there would be nothing in there that's relevant.
Your Honor, I understand, and I think that those justifications are to some extent why searches of the person don't have to get into this question, whether they may.
Just because he's quick enough to drop it, it no longer becomes the person, even though it's within 6 inches of him?
It's his property. He is entitled to do with it as he please if the police do not have any valid reason to. It's on his person when he's being arrested. I think, and I know that the cases discuss the fact that a search of the person is justified just merely by the fact of arrest. I think there's more underlying it than that. Specifically, their person is going to come with them in the car. You need to make sure they don't have something in their pocket, in their bag, that they could harm an officer with or destroy. But when we're talking about a container which the person does not want to bring with them,
Why?
Your Honor, but I think it's sheer speculation. I mean, of course we know what was in the bag after the fact.
Now, I mean, I'm just looking at Riley, isn't part of the rationale that there may be evidence on the defendant's person, and you don't want that evidence to disappear?
Of the offense of arrest. I think where things are going awry here is the state wants searches which find extras, right?
On the video, he's handing his cell phone and the fanny pack. The cell phone almost certainly has evidence that would be relevant. Now, you'd need to get a warrant to look at it, but you wouldn't want it to disappear, right?
It's the same thing. He's entitled to do whatever he wants with his cell phone until we reach the point where the state is entitled to seize it.
Assume that he's wearing his fanny pack, he's been cuffed with his hands behind his back, and that as he's walking to the police car, he's able to unhook the clasp on the back of the fanny pack. Assume I did not own a fanny pack when I was in junior high and know that there's a clasp. Assume that he's able to unhook it and it drops. Can the police pick it up and search it at that point?
No, because it's not on his person at the time of search. I know it seems like
Kept it on. If he hadn't taken it off, then it could be searched. So he decides what the officer can search while he's being arrested.
To some extent, yes, I think that's true. That's always true. The people decide if they.
Or takes it off. So the officer arrests him and then takes off the fanny pack to get him in the car. Can he now not search it because it's no longer on his person?
More difficult question when the item is removed immediately prior to search. I acknowledge that. That's more like the cigarette pack in Robinson, things like that. But when there is a significant break in time between the object not being available to the person and the officer searching it, let alone the person not wanting to bring that item with them, it's a different case than Robinson.
Gaskins?
And Gant, each independently decide this case. I think Gaskins and Gant, in fact, and I know I've got some Gaskins dissenters here, but in my view of the reading of Gaskins and those dissents, the heartburn was about maybe it's reducing searches in the automobile exception, frankly, the ability to search an automobile. But I think the way things have panned out is that those searches have not been restricted whatsoever by Gaskins. In my view, what was odd about Gaskins was the non-application of the automobile exception. I think the state loses nothing by not being able to search vehicles incident to arrest because it can almost always search them under the automobile exception.
Why isn't the justification for officer safety not at issue here when he hands the bag to Tammy and say it has a gun in it? Why can't the officer, before he lets her take the bag, even though Scullark is in handcuffs, why is that not justified?
Because it may be justified under Terry principles, but there just is no reasonable belief that he's in danger in this situation when he has distanced himself. They may be able to.
The defendant, but when he's handing it to the defendant's cohort, why is that not also justified then?
Search incident to arrest. Nothing about search incident to arrest doctrine has anything to do with searches of third parties. The case is cited no case. I've seen no case that says that is part of a search incident to arrest.
Because it hasn't, he's searching it before the third party gets the bag.
So if he takes it before, he still doesn't.
The bag to Tammy, and he says, before you give it to Tammy, I need to search it to make sure there's nothing in it. That could be, that she could use to harm me.
Constitutional search, Your Honor. There is no probable cause to search the bag. There is no, unless they could establish an exigency, something in particular, but officers cannot just open containers because they want to or because they imagine danger.
Gave you is because he is concerned there's something in there. And just because she may have called the cops, I think we all know domestic violence sometimes does a 180 and you no longer have a cooperative witness. She very well could be trying to help her boyfriend. So that example she gave, you're saying that would be an illegal search when the officer says, I'm afraid there might be something in that bag that I'm not going to allow you to just hand it to her. Let me see it. You think that's an illegal search?
He's within his power to tell her to put it down and thereby ensure his safety, no problem. He cannot just open and start looking through things. And I'll clarify, Tammy is not Mr. Scullark's partner by my abbreviation. It doesn't matter, I understand.
Well, no, it doesn't matter if she's the person who called the cops or not. Things go wonky.
And Your Honor, I'm almost out of time. I do want to emphasize the state and Judge Buller in his dissent have suggested that the search at the time of arrest view is the majority view. It's not, and it's not even close. By my review of circuit courts, only one, the First Circuit, has endorsed the time of arrest rule. Every other court, circuit court, which has addressed this post-Gaskins, including the Eighth Circuit case, which Judge Buller cited, expressly adopts a time of search rule. It's just several of them take a very wide view of possibility of access, the kind of thing the state's advocating for today. I think that wide view of possibility access runs straight into the Houdini, Hercules kind of criticisms which Justice Scalia and other judges have made. It has to be reasonably possible that the person can access the bag, that it's possible if they have superhuman strength and are magicians, that's not reasonable. That goes to the same idea in Thornton that we can't rely on unreasonable actions by the officers or belief by the officers to justify a search incident to arrest. Thank you.
Thank you, Your Honor. To pick up where we just left off, I actually think the circuits and other states' experiences are a little bit more diverse than my opponent would suggest. I would refer the court to the First Circuit in Perez from 2023. That was exactly the analysis that the state is proposing here, as well as Bembury from the Kentucky Supreme Court, cited in the dissent. Again, adopting the Robinson rationale for a search of a bag in the defendant's actual possession at the time of arrest. I admire the fidelity of Mr. Irwin's proposed rule, but I think it demonstrates its unreasonableness. It invites gamesmanship by either the defendants or officers or both, and the time of arrest rule for bags attached to a person is clear for application and keeps people safe. Is
immediately accessible. When you say attached to the person, how far does that go?
Facts that would demonstrate that the bag was actually possessed by the person either at the time of arrest or in the immediate proceeding. So the officer saw the person with the bag on their person, set it down for a second, the arrest begins. And I think that Bembury has a great application of that in explaining what the outer contours of that, because once we stray farther from actual possession, the more we're talking about that second Kymel exception for immediate area, and then we would need to show the objective interests are still, the two interests are still there objectively. I also would just like to point out that absolutely Gant and Gaskins are a separate rule. I mean, when we're talking about Kymel and we're talking about Robinson, the search for evidence of arrest is not one of the rationales involved, and yet somehow in the automobile instance, that is a permissible one after Thornton and Gant. Now, this court rejected that in Gaskins, but again, Gaskins was a case about cars. We know this from the text of the opinion. We know it from the special concurrence from Justice Apple, and I think it's fair to say from the dissent as well. Finally,
For you to prevail?
while I might be here another day asking to overrule Gaskins, this day isn't it. And the reason is because Gaskins doesn't apply. And stare decisis would, at least for now, say that that's enough reason to keep it. That said, if the court was to determine that Gaskins does apply, then a harder question is presented. I do believe Gaskins is distinguishable on its facts. Specifically, in Gaskins, there were two people present in the vehicle, and both were secured in a law enforcement vehicle at the time of the search of the safe. This case is different. At this point, we're talking about Mr. Scullark here within his wingspan, another officer, Tammy, and another associate. It is on facts distinguishable, even if we were to apply it. I just find that common sense and precedent tell us that this was a reasonable search, and the Court of Appeals applied neither. This court should vacate that opinion and affirm the district court. Thank you.
All right, thank you. The case of State versus Scullark is hereby submitted, and court is adjourned until tomorrow morning. Thank you.